This is the audio from the September 18, 2015 Bankruptcy Court hearing in the U.S. Bankruptcy Court, Southern District of Mississippi. In re. Lady Margaret Townsend, Chapter 7, Case Number 11-00167. Judge Edward Ellington presiding. This is a classic example of the Holy Ghost shellacking 101. Luke 12:11. And when they bring you unto the synagogues and unto magistrates and powers, take ye no thought how or what thing ye shall answer, or what ye shall say. For the Holy Ghost shall teach you in the same hour what ye ought to say. Exposing the Klan's corrupt judicial system.
Please be seated. The court has before it today the case of Lady M. Townsend, case number 11-00167. This case was filed on January the 18th, 2011, pursuant to Chapter 7 of the Bankruptcy Code. We have for hearing today a pleading entitled Creditors, Vogel Newsom's, motion for relief from order/judgment, motion for Rule 11 sanctions of and against Robert Rex McCraney Jr. / McCraney, and request to be advised of conflict of interest, close quotes. This is docket number 34 on the docket of this case. The procedure we will follow today is that Ms. Newsom will be allowed to go first and present whatever she cares to present. Mr. McCraney, who represents the debtor, will be allowed to reply to that, and then Ms. Newsom will be allowed to speak again in anything she has in response to that. The matter will then be taken under advisement by the court and opinion rendered, a written opinion rendered at a later date. The court takes judicial notice of its files in this particular case, in its own files, and it also takes judicial notice of the U.S. District Court for the Southern District of Mississippi, case style Vogel Newsom versus Mitchell, McNutt, and Sams, PA, et al., including the defendant, Lady Margaret Townsend. At this time, Ms. Newsom, you're recognized.
Thank you, Your Honor. First,
would you come to the lectern there, please?
Your Honor, good morning. First, before I get started, I wanted to, on the record, I'm just here special appearance only in regards to the jurisdiction of this court. I would like it in the record and recorded, but I would like to ask you first, reading the pleadings, I stated my objections for this court's lack of jurisdiction. So therefore, before we proceed, I'd like to know what legal conclusions or case laws you have to sustain your jurisdiction over this matter, in that the civil lawsuit that you mentioned was filed prior to this bankruptcy action. So this, the federal district court has jurisdiction first. So this, I filed a timely motion or pleading asserting lack of jurisdiction by this court. So that's why I'm here, special appearance only, to address the lack of jurisdiction of this court, because I believe in justice, and I just want it to be applied today. I submitted pleadings before this court. Each and every pleading has gone uncontested. I shared with Mr. McRaney that there was a motion to dismiss in this action that was never served on me. I asked him, does he have proof of service? So again, when procedures are proceeding, because I'm pro se, or probably not a legal attorney, I believe that in a court of law, it should be based on the law. It should not be based on skin color or things. And I shared even my concerns of some racial injustices in the handling of this matter, conflicts of interest. The matter in regards to the federal district court matter, I have filed the proper pleadings in regards to that to preserve that case. So we're standing here today. So while I'm aware of the puppet pullers behind the scenes, and I made that known to the court. So for the record, on the pleading that you said we are addressing today, under Roman numeral 1, I have lack of jurisdiction. So for the record, I need for you to clarify for me under what grounds this court has jurisdiction over this bankruptcy matter. And I cited the case law. This court has neither addressed or provided me with legal conclusions or evidence to support its jurisdiction of the matter, and neither has it been contested by opposing counsel.
Well, I'll speak very briefly. I'm not sure I'll answer your question, but to make a distinction, the district court case, which is case number 3:10-CV-00704-LZ-JMR, which was filed on December 3rd, 2010 by U.S. plaintiff versus Mitchell, McDutt, and Sams and others, I'd have no jurisdiction over it. It is in the U.S. District Court, and I have no jurisdiction over it. The bankruptcy case, which is here, which is case number 11-00167, that case was initiated by filing a petition in bankruptcy by Ms. Townsend. And in the Southern District of Mississippi, and this is pretty well true all over the United States, there's a general standing order that the district court entered referring all bankruptcy cases to the bankruptcy court. So that's the jurisdiction. That's the reason I have the bankruptcy case.
Okay, and I understand what you're saying, but it seems like, avoiding the question that I asked, you stated that the civil lawsuit was filed in December 2010. Her bankruptcy action was filed after that. And the legal conclusion and the evidence before this court, that court has jurisdiction over the matter. This matter, and I've already provided case law in the motion that we have before the court under Roman numeral 1, supporting that court has jurisdiction. So this court lacks the jurisdiction to entertain this bankruptcy action. It's there. It went uncontested by the opposing party. And as a matter of law, therefore, those claims and the assertions that I've made is to be taken as true. So I'm a little baffled because had that been me on the other side, vice versa, I really think that if I was sitting in that chair over there, you would have agreed and Mr. McRaney was on the other side. In other words, and like I said, I'm concerned about roles in what I consider probably discriminatory practices, abuse of the courts. Because like I said, if I was sitting over there and it felt the matter, he was sitting over here, I cited the case law, provided the evidence. And I've asked, have you read the pleading? This matter should have been referred back or should have been acknowledged that Ms. Newsom's pleading in the civil lawsuit has been filed first. So based on this was supposed to be a defensive move, the court lacks jurisdiction, so it's void. So this is what I'm here for. And I cannot, under the laws, as I stated, jurisdiction cannot be waived, and I'm not going to waive that. So if Mr. McRaney and the other courts want to continue to entertain such frivolous claims that he's filed on behalf of his client, that's fine. But as long as all I do is just go and make sure I preserve my claims. And I ask for evidence, I look at different things and what does the court stand on. And I'm asking you as I stand here today, based on the legal conclusions that I have provided, even numbered them for you, stated and identified case law, federal law, that this court lacks jurisdiction. So to sit here and try to usurp it over my objections and over the laws, the Supreme Court rulings, then I have serious concerns about that.
Well, all I can say is you've raised the issue, you've made your objection. It is a matter of record. Your point is preserved. If you are correct, if other side's wrong and you're correct, then your point has been reserved and you can get it corrected on appeal.
Well, see, the thing is, though, again, on appeal, again, waste of money, waste of time, for the simple reason the pleadings are not being answered. When you submit a ruling or order from this court, you yourself are avoiding addressing the issues. So then I'll do, for instance, a motion for findings and conclusion of laws, and you have tiptoed around that. So again, is this supposed to be a court of law? It's not working for us. And this is when I'm in the communities, I'm sharing with the public, because international leaders are paying attention to these frivolous proceedings by them, and the law firm Baker, Donaldson, Bierman, Caldwell, and Berkowitz actions behind the scenes in matters in regards to this. So I make sure I put it publicly in the record. So it said that, oh, she never made that known. No, that's not going to happen. And so with even the international interest, because this is supposed to be a country of example, look at the judicial system. They're here allowed to make a mockery of it. And I'm here, former background, doing paralegal work. So again, it's not registering with me. In other words, it's not like I have lack of knowledge and understanding the laws. And when I take the time to break it down, and you're sitting here this morning as we talk, and if I have the time, I can go down right here through here, stating the reason why this court lacks jurisdiction. And again, rulings by this court, you have tiptoed around it, usurped authority over matters that you lack jurisdiction on. So I have concerns about that, because then I ask whether or not there's a conflict of interest. And you tiptoed around that. I got that the other day. You ignored addressing the conflicts of interest. So therefore, what I did on yesterday, I filed the affidavit to support, which requires your recusal from this matter. But again, you seem to be adamant to stay on board. So again, I get concerns, because I know who the deep pockets are behind the scenes pulling the strings. They know me very well. And as I shared in the pleadings, when they made an appearance in the Newsom versus Entergy matter in New Orleans, Louisiana, they stuck their head out in that one. They took a shellacking so bad. And in the legal cases I take on, and when I do get an attorney, they threaten them behind the scenes that they have to let me know, oh, one attorney told me I have to live in Mississippi and feed my family. I take, those things concern me, because see, I'm not afraid of this law firm. Then another one, because you're Baker Donaldson, you're over the Mississippi bar, you start messing with people's livelihoods, then I get concerned. Threatening to have my attorney sanctioned or disbarred because they would refuse to drop lawsuits. And then when I proceed to do and get the pleadings filed, we have the kangaroos like Mr. McCraney, excuse the expression, but we have him showing up. So I follow the law. I get an attorney. And as a paralegal, I sit up here and I represent myself because of the threats against my attorneys. So I'm sitting here relying on a corrupt justice system, just like in the Entergy matter, when they didn't tell me that George Portis was on their payroll. Thank goodness I reported to the Department of Justice. They can say and fix it up however they want to, but he has been removed and impeached from the bench. And on their list, I see these attorneys just keep showing up that they have my cases assigned to. And again, so Mitchell, McNutt, and Sams, the law firm, even in that, failure to make an appearance. Errors. Me being pro se, if I had done that, they would have tossed it out right away. But because they're big prominent law firms like Butler, Snow, Phelps, Dunbar, and I'm sitting here African-American challenging these big, powerful law firms, the court cases are compromised. My attorneys are threatened. So here we are today, talking about jurisdiction against special appearance. I've asked this court, based on the arguments, the evidence that I presented, the case law, the fact that that federal lawsuit was filed, a district court lawsuit was filed before this one, and you have yet to show me, or even in your rulings, to show that you have jurisdiction over the matter. And again, you just have to excuse me. I'm just not afraid of these deep pockets. This is why I've gone public, international. I have the eyes and ears of world leaders. Russia, China, the report. I get them. They download my court pleadings. I get them translated in multiple languages, because those people come over here and practice law and go back to their country. And we're supposed to be an example. And then when you get what they call an educated black, another term used for us, we're abused. And that's why when I'm in the community, I said, this despotism government we're under, it's not a democracy. Integration did not work. Look at our condition, our communities. when we thrived before integration. We had laws and governments that worked for us. Now that we're supposedly relying on like I said, a democracy, which is a despotism, actually, oligarchy, with small groups like law firms like Baker Donaldson pulling the strings behind the scenes to get an undue advantage, tucking tail after they take a shellacking in the Entergy matter and refuse to show their face again. And if those things are not made known, and it's not like, oh, we didn't know that, Ms. Newsom. No, the court knows, because I make sure I put in the pleadings, I put the exhibits in the pleadings, and I even put the international interest as exhibits or within the pleadings. So again, I stand here today because Mr. McRaney in this court continues to talk about the federal lawsuit I have, that this bankruptcy naming me as a creditor, along with banks and other corporations, as a creditor. What a joke. And I even addressed that. But here we are, entertaining such foolishness and frivolous matters. Not being served with a motion to dismiss. And, oh, y'all quickly, earlier this year, dismissed. I had to notify. What is with playing with service? And I had to deal with Baker Donaldson on that, because when I served the President of the United States with eviction, people think it's a joke, but I did. Follow the proper procedures, certified mail, return receipt. And what do? They tear up the green card so I don't get it back. But once I went public and contact the international communities, they take that green card back together. That's called mail fraud and tampering. And I posted that in my blogs and forums for people in the world to see. But this is the justice. And then again, coming in time and time to entertain such frivolous bankruptcy actions as this. I take issue. I'm very upset about this, because the laws are not working. And this is what I share in the community. They are not working for us. We have a right to establish, under the democracy government that's already here, not the oligarchy that y'all are operating up under, a judicial process and system that's going to work for us and not against us because we don't have a lot of money like the McRaney firms or the Mitch McNutt and Sams. No, we don't need that. When we say we have the court of law, we have the laws, the Constitution to stand upon, and then it's abused because of the color of our skin. Again, before integration, our communities thrive. Look around Jackson. That's when I'm out spreading the real messages. Black Wall Street, look at that, thriving. Bombed in 1921 by the Ku Klux Klan because they didn't want to see us thrive, wanting us in their system. Well, I'm here before you all system, pleading my cases, putting my pleadings in, and you all are making a mockery of it. And that's my concern. If justice or the courts are going to work, then put on the blindfold and let them work. But don't be sitting up there peeping underneath to see who it is. Don't be threatening my lawyers and attorneys and trying to make it seem like I have frivolous lawsuits. No attorney would take a case if it was frivolous. And for them to tell me, especially one, that he was threatened, he has to feed his family, and then he goes and serves the judge in the matter afterwards, conflict of interest. And so even in this matter, I asked in my motion to recusal, identify the conflicts of interest. And what did you do, Your Honor? You tiptoed around that. I've got the document there. I asked for a sworn affidavit under the law. I'm entitled to get that. You refused to give me that. So why are we actually here? Is this just for a circus performance? I don't know. But I have serious issues to deal with, and that's what I'm out there doing in the vineyard now. Out there educating our people, letting them know what our rights are. This system is just not working for us. And again, I'll ask, you tell me what motion we're here for, but yet and still you have the legal conclusions. I can sit here, and I know what you would do. You say, oh, no, we got it. You don't have to read it into the record. And I may need to read it into the record because you're tiptoeing around it. I stated the case law where the bankruptcy court was to send this back to because my lawsuit was filed before this bankruptcy court, and you're still sitting up here wanting to take jurisdiction over the matter in which you lack. And you have yet in any of your rulings or orders, and neither has Mr. McRaney, contested my pleadings. And under the law, I don't have to go to law school for this, but just typing up my pleadings for these big prominent white law firms I worked for in the past, like Page, Kruger, and Holland, Mitchell, McNutt, and Sams. These things I learned. Goes uncontested, then it's taken as true. But this is not what's happening in this lawsuit. He just comes in and just make an appearance and sit up there and smile and, you know, the little eye contact and, oh, we got, I see the body language. I understand it. But I guess I'm not supposed to be that open and that direct. But that's the truth. And until we deal with the truth, then I want the international world to know what mockery this country is. It's a disgrace, especially when you let law firms, as I shared in my pleading, like Baker, Donaldson, Bierman, Caldwell, Berkowitz, take control of all facets of the government, infiltrate all facets of the government, and work it for racial discriminatory practices. Then I have to take issue with things like that. So again, I'm only here in special appearance, but I need to know, and I want it in the record today, what case law, so when I leave here and your ruling comes out that you're standing on to rebut the legal conclusions and the evidence I presented in this motion. I don't want to wait for the order because you've had this now. You said when it was filed, this pleading that I filed was June 17th. So I would just think in honesty, fairness, and justice, and in the integrity of this court, that you can provide me with a case law to support or rebut the one I provided, supporting that this case should just, because mine was filed first, should just be sent right on back to the district court. Don't sit up there and, oh, it's been dismissed. No, it has not. There's a conflict of interest, just like with Judge Portis, that they withhold. They get rulings in their favor. These are the things I've had to, corrupt judges, Portis, DeLauder, I put in the pleadings. What? All white? And then getting upset with me because my pleadings don't, as they say, look like a pro se pleading. Because our work is not supposed to look this good. I don't understand why we're here today. I put the pleadings there when uncontested. Today it hasn't been answered. And here you are. When I get ready to rule or when you're ready to appeal. See, again, this is what you all do. And this is why I share with the people. The system, the courts are not working for us. And under the Constitution, according to Abraham Lincoln, we have a right to throw these people out of office. Not overthrow the government, but the corrupt people in office. And that's why I made sure I served eviction on the President of the United States Congress. And it sounds funny, but those international people take respect that I followed the right thing. I care less about the color of his skin. I shared it with him when he got in there. Get in there and don't do right by the people. I can care less. Just do right by the people. Today I stand here and ask you to quit looking or peeping underneath the blindfold and render justice. You lack jurisdiction of the court, and I'm asking you to acknowledge that, or to provide me with legal conclusion and evidence based on the legal conclusion and evidence that I provided you, that you have jurisdiction over the matter, and not abuse or usurp your authority in issues or matters that's really none of this court's affairs. I did it, give another example of like the Mr. McRaney's. When I filed a lawsuit, when they took me down to Hinds County Detention Center in 2006, filed a lawsuit in that, naming John Lewis, the sheriff, Malcolm McMillan. Who did they bring in to represent him in that? But not only that, rather than John Lewis answering the complaint, he goes and filed these frivolous criminal charges against me for resisting arrest, disorderly conduct. But what he didn't know, I had already contacted the public and everything behind the scenes. Here I am out working for a law firm up in Cincinnati where my lawyer calls me. Ms. Newsom, why weren't you in court today? Well, one guess. And I told my lawyer, don't be trying to sell me out under the table to these Baker Donaldson. But did he listen? No. But at least the judge knew what to do in that matter throughout the criminal charges. I wasn't even there. Had he given in to the Baker Donaldson pockets, He would probably issue the bench warrant for my arrest. But like again, you don't find too many judges like that, nor lawyers. And I tell people when I'm out there, 99, and this is just being nice, but 99.80 of the lawyers are in the system tied up. So if you can find a .20, you're doing good. That's not going to compromise their job. They're going to take their oath seriously. So again, I'm only here in special appearance to let this court know it lacks jurisdiction. I'm not backing down off of that. I've seen nothing from this court. And again, Mr. McRaney and them had proper time to oppose this motion. They chose not to. In accordance with the law, the statement and the claims that I have made are to be taken as true.
All right, thank you. Mr. McRaney, you're recognized.
Thank you, Your Honor. Try to be brief. This is just a normal mom and pop Chapter 7 bankruptcy. My client has no money, solely on Social Security. I'm not a big law firm. I'm not a front for anybody, but the main thing is that Ms. Newsom, if she ever was a creditor, is not now. Her case, I believe I have supplied you with a final judgment. Her case in chief, and that's a certified copy, Your Honor, against Mitchell McNutt and others, including my client, Lady Townsend, has been dismissed. That's a final judgment. So she is no longer a creditor, period. We filed a motion to dismiss, and I know Ms. Newsom indicates and has told me that she did not get our notice, and we sent it to 2 places. But she said she didn't get it. I'm not denying. I'm not saying she's lying. But anyway, we did file it. I would like to go under that today. We did file it May of 23rd of 14, and it simply says it's because her case in chief in the federal district court has been dismissed. She is no longer a creditor, if she ever was, and has no standing. She's, the case has been closed, well, not closed, but it's been discharged. She did not file an objection to discharge. I sympathize with the court and Ms. Newsom, but this case she just has no standing, and we're asking that her action be dismissed and the case closed.
Is that been marked Exhibit 1?
Correct, and I gave Ms. Newsom a copy of it.
You want to ask to have it admitted in evidence?
Yes, sir. Yes, sir. I'm sorry. Please have it admitted.
All right, let the final judgment dated October 23rd, 2013 in U.S. District Court, mark Exhibit 1, let it be admitted.
So, lacking standing, which she just has no standing. She's not a creditor. Her case has been dismissed. My client's a little old lady, and we just need this case closed. Thank you, Your Honor.
All right. Mr. Newsom, would you like to be heard further?
Your Honor, I thank Mr. McRaney for his performance. I have no sympathy for Ms. Townsend's financial situation or conditions, because during the federal investigation, she lied. So now they want my sympathy because she's being slapped with a lawsuit. He gives as Exhibit 1 a final judgment that has been contested. He mentions that there was a motion to dismiss that went uncontested, but I asked him, and even in the last hearing,
Wait, say that again.
he mentioned a discharge or motion to dismiss file that wasn't contested. I was never served. Now, give you an example. If you look at the court's record, this court's record, we had an issue with something similar to that regarding a hearing. I notified the court to let the court know that I was never served. The court took the initiative steps to make sure that I was served, sent it back out, things like that. But in our last hearing, when I let Mr. McRaney know, Mr. McRaney did not even take the time to say, well, Ms. Newsom, here is the motion. He has no proof. All we're standing here is his word. He's an attorney. He has access to the court electronic system. I gather he filed that by the electronic court system when he filed it. Again, by me being pro se, I don't get notices like the attorneys do that the motion's been filed. So for Mr. McRaney to use, for instance, if that's what he did, the court electronic system, and not serve me, that's an abuse right there. And that's why I even asked for sanctions to this date. With that knowledge, he's never served me. I have no copy of this motion to dismiss or discharge. Now, to the Vogel, Newsom versus Mitchell, McNutt, and Sams. Conflict of interest exists there. The proper pleadings have been filed to preserve that case. And there's no need of the court trying to, because I met this African-American attorney for the ACLU when I was at a black conference in St. Louis, Missouri, that I used as a sounding board to let me know what I need to do. And I've done those things. So when I see foulings or frivolous final judgments like this, I've already preserved the case. File the proper pleadings. Even this matter, if you file another one or whatever, things like that, sanctions. I paid the sanctions. I've done that. Then when I come and file sanction against McRaney, what do y'all do? Knowing he hasn't even abided by the court, he's used underhand tactics to gain an undue and unlawful advantage. And as I shared with him, if you believe so strongly in your case, why did you have to pull such tactics? Why did you have to withhold the motion to dismiss? Oh, my client's all broke. She has no money. Well, boo-hoo-hoo. She's only suffering from what she has sown. You reap from what you sow. She went and lied during a federal investigation, and I have the documents, which made it good. Then when she gets slapped with a lawsuit, she wants to go file bankruptcy. And like he said, naming me as a creditor. It's already an argument that I should have never been named as a creditor. But again, this is where we are. So to sit up here and say, oh, well, there's the final judge. This is what I'm saying. Just frivolous, foolish arguments, a white-controlled, racist-controlled judicial process that's not working for African-American people or people of color. And one thing about the law, it has no color. That's one thing about the law. It has no color. You say equal protection under the law, equal rights under the law, that's not happening. Because I'm challenging the big, deep pockets, Klan-connected, affiliated Baker, Donaldson, Bierman, Caldwell, Berkowitz. The one who, as I mentioned in my memorandum, or my affidavit on yesterday, it was filed with the court. That's legal counsel to the federal judges. So basically, while you're sitting on the bench. I'm not that naive. I put it in the record for everybody to see. They're behind the nominations of federal judges. So again, why are we here? Oh, I'm not a big law firm. Read the pleadings. Mitchell, McNutt, and Sams, after the G shellacking, hides behind the scenes and pull the string behind the scenes. They don't want anyone to know they're involved. So please spare me. I'm a small law firm. I'm not big. I can assure you, we can look at your bank accounts. Okay? So that's my thing. So to come up here, again, not addressing either this court nor Mr. McRaney, the pleadings are filed. I'm abiding by the law. And I'm just going to go and quote a nice little favorite scripture that I like. In that King James Version, 1 Timothy 1:8. The law is good if a man use it lawfully. But then if you go on down in a few more verses, it tells you who the law is for. the liars. Okay, it gives you a whole list of who the law is for. But it's supposed to be, again, the law is good if a man uses it lawfully. Don't be up in here abusing the judicial process. Don't be trying to use the fact that you're white as an upper tool to get justice or to beat someone because of the color of their skin. The law has no color. Put the blindfold back on and quit peeping underneath the blindfold, trying to see who's paying who's doing what, and abide by the law. As I shared, no big law firm, but I can go and get attorneys, but those big law firms can threaten my legal counsel, so then when I show up pro se, they want to try to say it's frivolous. They want to slap me with sanction. Yes, Your Honor, I paid sanction things, but when I come and file sanction against Mr. McRaney and the foolishness and the lawsuit frivolous bankruptcy action that they brought, you all avoid that. And under the law, he didn't even contest it. He didn't object to that. And here we are with the motion stating why I asked for sanctions. They can threaten my attorney, Baker Donaldson, and them, with sanctions and disbarment because they're the president of the Mississippi Bar, Tennessee Bar, president of the United States, legal counsel to Phil Bryant. And that's why I tell the people, that's why y'all are having issues with that flag. I just keep it real. So when I come in here, no, I'm not here to play patty cake with Baker Donaldson, Butler Snow, McRaney and McRaney, and neither will I pull out any tissue or napkins for Lady Margaret Townsend. She knew when I was at the firm and the way they treated me there, the only African-American in the firm, and then she wants to go and lie during a federal investigation, and now Mr. McRaney wants me to pull out napkins and handkerchiefs because she's broke. That's not going to happen today. She's only reaping from what she sown.
All right. We stand adjourned. Thank you very much.
Thank you all.